You were hurt offshore. You know you have rights under the Jones Act. What you may not know is that the Jones Act statute of limitation is 3 years, and that window has traps that have ended valid claims from workers just like you. Maybe it happened fast. Maybe it built up slowly over months of hard physical work. You've been focused on getting better, managing the pain, figuring out what your future looks like. Filing a lawsuit feels like something for later, when you're on the other side of all this and can think clearly. I hear this from injured seamen all the time. It makes complete human sense, and it has cost workers everything. 3 years sounds like a long time until you account for the investigation required to build a real claim, the medical documentation that has to be gathered and organized, the witnesses who need to be located before they move on to other vessels or other companies, the evidence that needs to be preserved before it disappears. 3 years is not what most people think it is. Once you understand what actually happens to evidence and witnesses over time, by the time we're done, you'll understand exactly when that clock starts, how the discovery rule works for injuries that develop gradually, why waiting until you are healed is a calculation that has ended valid claims, what happens to critical evidence while you wait, and what your realistic options look like if you're already close to the deadline. The general rule is that the 3-year period begins on the date the injury occurs. If you slipped on a vessel on a specific date, that is the starting point. The clock runs from that day, regardless of when you decide to take action, regardless of whether you understood at the time that you had a Jones Act claim, and regardless of how long it takes you to fully appreciate the full severity of what happened. But maritime injuries are not always a single identifiable event. Repetitive stress injuries from years of heavy lifting on a vessel, hearing loss from prolonged exposure to engine noise and industrial equipment, back and joint conditions that develop gradually and worsen over time with continued physical work, occupational diseases from chemical or toxic substance exposure on a boat. These do not come with a single date you can point to as an injury date. The discovery rule. For injuries that are not obvious on a single day, the statute of limitations may not begin running until you knew or reasonably should have known that you had a significant injury connected to your work. This sounds like protection, and in some respects it is, but reasonably should have known is not a forgiving standard. Courts look at when you had enough information to begin investigating. If you had symptoms that you understood were related to your work, the clock may have already been running for months or years before you decided to do something about it. The discovery rule is not a clean extension. It is a fact-specific determination that requires careful legal analysis. The waiting to heal trap. This is one I want to spend real time on. The instincts to wait until you're physically recovered before dealing with the legal side makes complete intuitive sense. It's what a reasonable person would want to do. The problem is that the legal filing deadline does not pause for your recovery. 3 years from the date of the injury is 3 years from the date of the injury. I have had conversations with injured seamen who came to me with a clear liability documented injury, witnesses available who saw that happen, and a statute of limitations that expired in 5 or 6 weeks. That is not enough time to investigate the facts, gather and organize the medical evidence, locate and interview witnesses, draft and file a proper complaint, and do everything else required to actually protect the claim. Some of those conversations ended the way you might imagine, not because the underlying case was weak, but because there was not enough time to do the work right. What happens to the evidence while you wait? Evidence in maritime injury cases is not preserved automatically. Witnesses move on to other vessels, other companies, other cities, and their memories of what happened on a specific day, months or years ago become less clear over time. Vessel maintenance records, safety inspection logs, equipment inspection reports, these documents can be lost, destroyed as part of routine record retention policies or overwritten during normal vessel operations without anyone doing anything deliberately. The vessel you were injured on may be sold, renamed, or dry docked in a way that eliminates physical evidence of the defect or condition that caused your injury. Starting the legal process early, even before you have finished medical treatment, creates the opportunity to preserve what you need. Your attorney can send a preservation notice to your employer that creates a legal obligation not to destroy relevant records. That notice, sent properly, is a powerful tool. Sent after the documents are gone, it does not accomplish much. What happens if you're already close? In limited circumstances, legal doctrines can extend or toll the limitations period. Fraudulent concealment applies if your employer actively hid information about what caused your injury. Equitable tolling applies in narrow, extraordinary circumstances. These are real doctrines, but they are narrow, and whether any of them applies to your specific situation requires a real conversation with a maritime attorney, not a general answer from a video. What I can tell you is that if you think you may be close to the deadline, you need that conversation today, not at some point when things settle down. Your maintenance and cure clock is separate. The 3-year Jones Act limitation period is not the only time-sensitive issue when you're injured offshore. Your maintenance and cure rights are a separate obligation that your employer owes you from the moment you are hurt. The longer you wait to assert them, the harder it becomes to recover back payments for the time you were entitled to maintenance and cure, but were not receiving it. Both tracks need to move at the same time. The Death on the High Seas Act trap people do not know about. There is a separate federal law called the Death on the High Seas Act that applies to certain deaths occurring beyond 3 nautical miles from shore. It generally uses a 3-year filing period as well, but it has different rules about who you can sue and what damages are available. If a family member died offshore, the applicable law and what your family can recover depends on heavily where the death occurred and under what circumstances. I raise this not because it applies to every viewer, because it illustrates a broader point. Maritime law has multiple statutes with different rules, and the one that applies to your situation is not always the one you assume. If your case involves a fatality, or if you're filing on behalf of a family member lost in a maritime accident, the analysis of which law controls and what damages are available is even more critical. What to do right now if you're injured and have not yet taken action? Contact a maritime attorney. Do not wait until you feel better. Do not wait until you have made up your mind about whether to pursue it. And do not wait until you think you have all the information you need. The first consultation is about getting oriented, understanding your rights and your timeline, and getting the evidence preservation process started. None of that requires you to have already decided what to do, but it does require that you not wait past the point where the decision has been made for you by the clock. Maintenance and cure and your Jones Act claims run together, not in sequence. If you have not looked into your maintenance and cure rights yet, that is the next step. Missing the filing deadline is at the top of their list. Employers count on you not knowing your deadlines. Contact information is in the description. If you have any doubts about where you stand on the filing deadline, please just not sit on that uncertainty. And if you've been in this situation, drop it in the comments. You're not the only one who has found themselves closer to the deadline than they realize.